Welcome to another of NJAPM's webinars. Today, our topic is alimony, budgets, statutory factors, and rules of thumb. We're going to be talking with Gabrielle Strich and Larry Jones. Gabrielle is a mediator, collaborative lawyer, and attorney in Cranbury, New Jersey, with over 35 years of experience. She's been a mediator since 1995, started the peer groups, and is currently president of NJAPM. Larry Jones is a mediator, arbitrator, and professor at Montclair University and Monmouth University. He's a former family court judge. So welcome to both of you.
Good afternoon, Carl. Good to have you.
Glad to be here.
Okay. So first, to everyone who's looking, as usual, if you have a question as we're going along, please use the chat function. I will be looking at the questions coming up. I may ask them right away. I may delay it a bit in as much as maybe it's coming up a little bit later in the presentation. So let's set a background here for what we're talking about and the types of things we're talking about. So let's assume that this is a private mediation rather than a court-connected one. If you feel that some answer would be significantly different or you want to talk about that, please do. But generally, it's a private mediation. The parties may or may not have attorneys. But if they already have attorneys, they have not done the CIS, they've not done the balance sheet, the monthly expenses, etc. So those things are yet to be done. Okay. So normally when I was mediating, and I think most mediators started with parenting and then went on to equitable distribution, alimony, child support. Not everyone does that, but most people do. So is that what you do, Gabrielle?
Yes.
Okay. And Larry?
Yes. If there's a custody issue, it's really, I think it's helpful to try to get that taken care of first, and then you move on to the financial issues, because custody may impact the financial issues, obviously.
Okay. So when do you assign the work of doing the budgets?
Got it?
Oh, I'll go right ahead. So as you say, I start with the addressing parenting issues, even if it's not like they have a big dispute. So, excuse me, still needs to be outlined, worked out, clarified. I'm sure you find this also, Larry and you, Carl, that they think they've solved it and they know everything, and then I start asking questions and, oh, they didn't think of that and they didn't think of this, right? But once we're past the parenting arrangements, then I ask them to, I don't do the budget yet. The next thing I do is equitable distribution. So I have them focus on that. And I have a spreadsheet that I like to use, and I put it up on the wall, and we go through step by step on the equitable distribution. Then I have them work on the budgets, both what was it like when it was normal times in the marriage, and what do they foresee living separately and apart. And then, so I have them do a first draft themselves. And I have the ability in the program I use, EasySoft, to send it to them where they can fill it in, and then it can be inputted into my program so that we save time and money on not having to draft everything from scratch.
So when you assign it after they've done equitable distribution, how much time do you give them to do the budget? That was always the hardest part, which was, first of all, they don't like doing it. And they really they couldn't get it done in a week usually. So how much time do you assign or have a break so that after equitable distribution, they can now move on to alimony, do the budget part?
Are you asking me or Larry?
Yes, I'm going to ask you and then I'll go back to Larry.
Okay, so I generally schedule mediations approximately every 2 weeks. So it would be 2 weeks that I give them. However, that all gets adjusted for our schedules, everybody's schedule involved, and the situation. I've had cases where one party had to fly up from Texas and we met all day Friday, all day Saturday, all day Sunday, and they walked out with a done deal, right? So it all depends on the exact situation, but you should be aware that when I give it to them, I find 90% come back and it's not really right, if you know what I mean. They made a stab, that's good, but there's a lot of work that's needed to really go over them and get them so they make sense. And what do I mean by that? I mean,
okay.
I'll
Okay, let me stop you there because we'll talk about that in a minute. Larry, is that about the amount of time you give people to?
Yeah. Well, yeah. I mean, every case is going to be a little fact sensitive. Obviously, some cases are going to need, more financial information than others, just by its very nature. What I tend to do, and there's no right or wrong, black or white way to do this, but I tend to send the materials all at the very beginning, just so they have it, including the case information statement. That doesn't mean I need it back immediately. But this way, some people, they just get started on it faster. They need more time to work on it. And others, they put it on their shelf and they get around to it whenever, almost like doing their taxes. And some people do it quickly. Some people do it, right at the deadline. But, the way I look at it is, get them it all in the opening packet so they at least familiarize themselves with it. And then obviously, once you're going to get into the financial issues, particularly if you're talking about alimony, it helps to have I think it helps any mediator to have those case information statements in front of them from both sides before having any kind of real significant discussion on alimony relative to the specifics. You can talk about the general, concept of alimony and what it is and how it works without the CISs, but if you're going to try to come up with numbers, I think you need the CISs as part of that analysis.
Okay. Now, what do you tell your clients when they ask, why do I have to do the budget? It's a lot of work. I don't want to do it. Why do I have to do it? Okay. Larry?
What I tell them generally is this. I said, first of all, in the event let's say your case doesn't settle. In court, it's going to be required generally to have a case information statement anyway. So you're not doing extra work. You're just doing something which in one form or another you're going to need. Number two, if you do settle your case, you're still going to want to have some kind of basis, some foundation for the numbers upon which your settlement is based, so that if there's an issue down the line, if somebody is questioning whether it was a fair resolution or not, if there's a question as to whether there was full disclosure by each side as to income and assets, that's the whole point of the case information statement. That is exactly why the court requires it in a contested case. And so, and I also explained to them, it makes the mediator's job easier. And you basically can save money that way because you're giving the mediator more information to make informed, suggestions, as the case may be, or recommendations. And that it'll be very hard to do a case without a case information statement unless the case is so simple. For example, two people, they stipulate that they've only been married for 3 years. They're both W-2 employees. No one's looking for anything from each other. They're just dividing up some personal property. You may not need a case information statement as much in a case like that. But I think when you explain to them what it is, I think most litigants get it. They understand it. It's not just pushing papers or just filing documents just for the sake of doing them. And I haven't personally seen a lot of pushback from litigants who refuse to do one once it's explained to them what the whole purpose of it is.
Okay, Gabrielle, what do you tell your clients?
Well, everything that Larry said, but I also say that one of the most important questions for people going through a divorce is they want to know how they're going to manage financially when it's over, when they're separate. And there's no better way than creating budgets for the future so they can see what they have to do and what they can't do.
Okay, now let's say you explain that to the client, and these are fairly sophisticated people, and they say, well, thank you very much. We just don't want to do them. We know what we want to do. We're just not going to fill out the budget. And so what would you do, Gabrielle? I'm not going to do it.
first of all, I'm going to ask, well, I had a case where the woman made 1.3 million a year as basic before her bonus, and he only made 250,000 a year. And I was just a lot less concerned about budget in that kind of circumstance, because really there was enough money for, and they had 20 million in savings.
So in that case, you would have said, no, you don't have to do it. I'm not going to make you do it. Or is there any case where if they said, we're not going to do the budget, you would walk away?
Well, I'm a big believer that where there's a will, there's a way. And if people want to settle, we can find a way if we're thoughtful and creative and work together to get it done. So I wouldn't, first of all, it would be, is this an alimony case? Maybe it's not for whatever reason.
It's an alimony case, that's what the topic is.
Well, in my view, the court rules require it, and I explain it. I just say there's really no choice card here. The court rules require that you do budgets when there's alimony, because things change in the world, as we are very much aware of nowadays. To you individually, the world, 100 things could happen that we, some of which we could predict and some of which we can't. And we have to have a baseline to judge what is the right way to do it.
Right. The question is, would you walk away if they said no?
No.
Okay. Larry, let's go to you.
I wouldn't walk away necessarily, but I would make sure that I put in writing to both sides in a letter, number one, that I strongly recommend the case information statement, that it's very difficult, I believe, for a mediator to really do his or her job without those case information statements. And if the parties are insisting on proceeding without the completion of case information statements, that they understand that they are, to some degree, impairing the process. So that way it doesn't become a situation where after the fact, after someone who has refused to turn over a case information statement for any number of reasons comes back and says, well, the mediator should not have helped us resolve the case without the case. Try to shift the blame to the mediator, which would not be appropriate in the hypothetical you set forth, because it's they who are insisting not to submit it, not the mediator.
Okay, so let's say they've refused to do it, and you've gone ahead and you've done the MOU, and they're now in court. It's an uncontested divorce, obviously. Larry is a judge. Do all judges require budgets?
No, I wouldn't say. I would say no. Judges have a fair amount of discretion in particularly with uncontesteds. Some want to see, they won't put something through without having the case information statement. Some will allow it to go through even without the case information statement. Some will ask questions. When I had saw a case, for example, without case information statements, I would bring it up. Generally, I would ask the litigants, I'd say, there's no case information statements. Do you want to adjourn this so you can complete the case information statements? Do you understand that without a case information statement, there's no foundation or no foundation in terms of what the budgets are, et cetera. And sometimes if the parties felt they didn't want to proceed with a case information statement and it was a settlement, I wasn't going to stand in the way of a settlement because there's a very strong public policy supporting settlement of litigation. However, I wanted to make clear on the record that they were aware there's supposed to be a case information statement, that there could be problems down the line if there's not a case information statement for modification applications in terms of establishing what the lifestyle was. Perhaps there would have been an agreement on that. And to really, essentially help educate the litigants as far as that's concerned. That being stated, if they refuse or don't want to file a case information statement, but they still want to get divorced, and they indicate that they are voluntarily entering into the resolution, I wouldn't stop them from proceeding in that fashion. Okay. Another judge might have.
Does that change by judge, or is it by vicinage, or is it just random?
The rules talk about case information statements, but the rules also talk about relaxation of the rules. There's a general rule 1:1-2 which talks about relaxation of the rules. So it really, to some degree, depends on each judge. I don't think it's a vicinage thing too much. Perhaps it is in some counties. I never saw it that way. I sat in Ocean, and I know that different judges handled it different ways within Ocean County. I certainly prefer to have the case information statement. I prefer to have that. But if two people came in and they wanted to get divorced and neither one wanted to file one, there is this very strong public policy permitting people to get divorced if they want to get divorced. That's why we have no fault divorce. So as long as they understood, as long as I was comfortable that they understood that they had a right to file a case information statement, that they could have adjourned it, that there could be issues down the line, it wasn't going to stop them and force them to stay married until they filed a case information statement.
Okay. So you're now, you've sent out the information, taking a step back. You've sent out the whatever Excel spreadsheet or whatever you have that they're going to put their expenses on. Do you require them to do it living together and living apart? Gabrielle?
Yes. The living together really is like during the marriage, and then living apart, what it's going to be like in the future, because it's very instructive. And I always go through line by line. First of all, a lot of my clients are pretty amicable with each other. They don't want to stay married for whatever reason, but it isn't one of these, hate situations. And so a lot of times if they're living together, they do the marital budget together, and they help each other even with what they anticipate their expenses are going to be going forward. And then I sort of, obviously, if I find as I start going through each number with them, that they're really on target, and I look at whether it makes sense, right? So I look at what is their net income during the marriage, and what do they anticipate their net income each will be going forward. So the number has to be pretty close to that amount, because it includes a savings component. That's one of the budget items. And if it's too low or too high, it's not a good budget.
So let's say they have come in, and I always ask people that if they could work on their budget together, that would be the best thing to do. If they can't, don't do that. But if they could, so they have worked on it together. They've now come into you, and they have their monthly budget living together, and there's the number. Do you go farther and look at all the numbers as long as they've agreed to it?
I do. Well, first of all, I look at the bottom line and see whether it's a number that I said that makes sense with their income or their anticipated income for the future expenses.
Now, just living together, just the living
together portion. I do look at it. And very commonly, it's too low or too high. It's not always too high. It's often too low. So and yet they can't explain what happened to that $10,000 a year of income that is missing in their budget. So we have to kind of go through. But let's just say, for example, it's on target, and it really is consistent with their joint net income during the marriage. Then I might check a few things to see that they make sense, but I'm not going to go through each one for the sake of doing that. If they seem like they really do have it right, which by the way is extremely unusual, then I'm not going to recreate the wheel. That's not right.
Okay, so when you say make sense, do you mean it in the sense of they're spending too much money on it, or that accurately reflects what they are spending?
Accurately reflects what they are spending given what their net income is.
Okay. Larry, do you follow the same kind of process? If again, these are where the clients have done the living together budget together and they've come up with a number, what do you do at that point?
Well, first of all, I think it's important to see when they do their case information statements, if their numbers are close to each other. Sometimes people, it's almost like they get along so well, you wonder why they're even getting divorced. Then they do their case information statements together, they come and go together, and their numbers are literally exactly the same. Like Gabrielle says, that doesn't mean they're necessarily correct. There could be a misunderstanding of the case information statement. A lot of times in the case information statement, it says in the top pre-printed language, it says go on a monthly basis, whether it be on a monthly. So, but then there are items like snow removal. And people just put, if they can't happen to come to you in the winter and there was just a snowstorm last week and they spend $200, that's the number that's going to go down there. If they come to you in July, they're going to put 0. They don't amortize it over the 12 months. The same thing with lawn care and vacations and stuff like that. People put all kinds of things in there, which really throw off the budget if you don't double check to see that it makes some sense. If they put in $5,000 for vacation, you have an idea that they made a mistake, that they're not doing this on a monthly basis. They're throwing some things in annually, some weekly, and some not at all. Once you go through that, if you see that the numbers are kind of in the same ballpark, this is me, just for me I'm talking, then I know at least there is essentially a stipulation between the parties, a consistency in what they each believe they were spending on a monthly basis, regardless of how you got to that final number. You may, when you go down the list, you may say, well, someone's putting more on the food and less on the clothes, or more on smoking and less on savings. But if you get to the same, roughly the same ballpark number, you know what the general lifestyle was without having to go through every single item. In some cases, you do have to go through specific items if there's a real difference, a significant difference in what someone's saying. The biggest one I tend to see is food and groceries, which is one of the first things on the Schedule C. Someone will say it's $1,000 a month, and the other person will say $200 a month. But did you have separate refrigerators? How did that work? So you have to have some discussion about that, and sometimes they reach an understanding that maybe one of them inflated accidentally and the other one, went too low, and you kind of come up with some numbers. Or I might tell them, well, especially if they're still living together, come back in 2 weeks, do your groceries, bring back a receipt, and let's take a look, do a normal grocery order, and let's see what it is. Like Gabrielle says, sometimes one of the benefits of a case information statement is it actually forces people to understand their own budget. Even in intact families, you see people marching around, sometimes they have no idea what they're spending on a weekly basis. They're spending it, but they can't really tell you. It's just like an educated guess as to what they're spending. So you kind of have to direct them in that manner. If in fact their numbers are very different in terms of their total budget, then you have to start looking, the mediator start looking to see mathematically why. Where are the big differences on specific items? Sometimes you'll say someone just didn't put down the mortgage payment. They skipped the whole section, or the car, they put down the car payment, but not the insurance. And sometimes it's just a general mistake. And other times it's not. Other times there are just huge gaps of views. And if there are, that's when you have to start looking for some documentation that might bridge that gap, I think.
Okay. So when you look at, we're all doing this because of marital lifestyle. Is that correct? Sort of, it defines the marital lifestyle, the living together.
Well, that's one of the reasons, yeah.
Okay. So my question is the marital lifestyle described by or defined by the individual amounts that people spend? Like one person's a saver, one person's not a saver, one person spends more, one person spends less. Is that, an individual lifestyle for each party? Or I have other experts, financial people who say, that's not the marital lifestyle. The marital lifestyle is simply everything the people spend and everything they save. That's it. All the other stuff is not important. They're just details. So, and let me go farther. Everything you spend also includes credit card debt, gifts from third parties, whatever. So that's all income. And what you save. So which one of those views do you ascribe to? Larry, let me go with you, Larry.
Okay. Traditionally, there was a tendency for there to be a focus on what you were spending, consumption items. That's a Schedule A, B, and C. However, over time, including a recent appellate division case, published opinion from a few years ago, the focus has shifted to other things such as savings and investing. It's not just what you spend, because if you got more alimony by being a spendthrift, you're actually rewarding someone who's being financially irresponsible. In an intact family, you wouldn't spend every dime that comes in. You would naturally want to save or invest money for your future. That's what you're supposed to do. That's why they set up things like IRAs and stuff like that with tax incentives to encourage people to do those things when their employer isn't doing it for them. So you have to, on the Schedule C of the case information statement, one of the items, and it was always overlooked in a lot of cases, I found, one of the specific line items is savings. It's actually part of the budget. And it's been that way before these new cases came out. It's been that way for years and years, but sometimes, in fact, in a lot of cases, you'd see it would just be left blank. That's even though in the asset section of the case information statement, it was clear that the parties were in fact saving money. They had money in the bank. They had an IRA. They had, whatever. They had a 529 for their children's education. So clearly savings was one component of the budget. You take a look at that in addition to the recent case law, I think in any alimony case, savings has to be a consideration if it existed previously. If it didn't exist previously, it wasn't part of the lifestyle.
But what I'm asking is the marital lifestyle simply defined by everything you spend and everything you save? That's what it is. And everything else is a detail that is not that important.
Okay, as a starting point, as one of the starting points in analysis, my answer to that would be yes. That you have to see between the combination of what you save in total and what you spend in total and invest, and you did it together, that was the lifestyle. Now, that doesn't mean that lifestyle has to stay exactly like that forever, or that alimony has to be raised at such a level to have one party continue that lifestyle to the complete detriment of the other. The real problem with that alimony analysis these days is the majority of cases, when one household becomes two, neither can afford the lifestyle, whether it was just on spending or spending and saving if there was savings. Gabrielle described a case where the people were very wealthy. And in that type of case, it might be an exception, but the majority of litigants don't fall into that category. So you have to kind of look at it from another angle in the middle class situation.
Okay. Gabrielle, let me turn to you and ask you the same question. The question is, can't you just say that the marital lifestyle is described by everything the parties spend and save? So whatever it is, the total amount, that is their marital lifestyle. And all these individual line items are not important.
Well, the individual line items tell you something. So is this a couple that saves 20% of their net income? I actually had a very interesting mid-marriage case that I want to tell you about very briefly. So the problem, they loved each other, they wanted to stay married, but they were driving each other crazy because of the savings issue. So the husband insisted that wife pay for all the expenses of the home disproportionately to joint income. And he took his money and put it all in savings. And she's like, well, why can't I have a savings in my name? Right? And he didn't see that as a problem. So we actually worked out a whole deal on that issue for them, and they were able to happily continue in their married life. So it isn't just total expenses, including savings. It's also, how is it proportioned between the parties? It's also, well, let's say they never saved, and now they're starting to realize they need to save. We have to then build it in to the future budget, which is really hard because now you got two households, which is more expensive to start with than one. So, and also when they're buying a car, are they buying a Mercedes or are they buying a Honda? And I think it gives you a flavor of their lifestyle. You have to look at not just the numbers. The numbers are nice and objective way to look at it.
So,
but I think you look a little more than that.
Gary has asked a question, Gary Borger, and he's given a statement here, but let me sort of put it into a question for him. So if you're saying that the line items are important, so that pre-divorce, the wife was a saver and the husband was a spender. But post-divorce, and when you're looking at alimony, are they locked into those kinds of spending patterns? They can change it, right? They can, instead of being a saver, a spender. And so again, do the individual line items really define their lifestyle, or is it the total amount of money spent and saved? And then I'll move on.
The line items matter. I said before they're not important. They are important. They're just not. They're not the only part of the analysis. If you have a budget, you look at the total budget and you say, okay, like you said before, Carl, is it you take a look at what the total savings and total spending is? Is that the lifestyle? Well, it is. Obviously, it is, because that was what they spent, right? That was their budget. However, the analysis of alimony doesn't, it's almost never in the majority of cases going to be preserving that exactly the way it is. It's trying to reach a fair and equitable resolution of how you take that lifestyle and divide it fairly between two households. So to do that, you have to look at the individual expenses and see what can more reasonably be trimmed than others. You can't compare the mortgage, for example, to vacations. You can't compare food to smoking or gambling, and yet all of these items are on the actual budget. Savings, savings is a great thing to have, but it may not be as important as, for example, paying your gas to go to work. So you have to take a look at the budget to see how you got to the budget, how you got to the lifestyle, and then use the itemization of items in schedules A, B, and C to see where you can reasonably trim. The case I was talking about, by the way, with the savings, for those who are not attorneys, it's called Lombardi. Lombardi versus Lombardi is 2015 published opinion. So any mediator who is doing an alimony case may want to read that decision, because it really underscored and emphasized the point that savings is a legitimate factor in a budget for alimony purposes, and you don't penalize the person who was appropriately being frugal and not being a spendthrift in their lifestyle.
Okay, so let's turn now to the living apart budget. You've gone through the living together one. You've now come up to the living apart one. Generally, they're going to be they'll be spending between them significantly more than they did in the marriage. If for no other reason, now you have a separate residence. So, say an average of $30,000 more a year. Take care of residents and some other stuff. So what do you do with those two budgets? Now you have two, one for her living apart, one for him living apart, or her and her, him and him, whatever. So what do you do then? Do you go over those line by line?
The budget, for myself, when people don't have a specific plan in terms of where they're going to be living, and a lot of times they don't. If two people come in and they're living together in their home and they're getting divorced, but they don't know where they're going to be residing, or whether they're renting, or whether they're buying a condo or buying a new house or whatever, taking in a roommate, a lot of the future budget to some degree becomes speculative. It just does. A lot of it's guesswork. And so that doesn't mean you can't settle the case or you have to wait to see what happens, but there has to be a planning of an appropriate budget, a reasonable budget based upon not only lifestyle, because lifestyle is not the only factor in alimony, it's one of the factors. And so it's not all about lifestyle. You have to look at need, you have to look at ability to pay, you'll have to look at child care responsibilities, you have to look at equitable distribution. All these things are in the statute itself and as factors in the alimony statute. So the real discussion becomes, well, what do you feel, even if you don't have the specifics of where you're going to be living or what your gas bill is going to be or what your food bill is going to be, what is a reasonable budget? What is a fair budget for both sides to be able to move on with their lives? I try to couch it in terms of fairness. I try to explain to the litigants, say, look, if you were to go to court on this, a family court acting as a court of equity, which means court of fairness, is going to try, in all likelihood, to reach a resolution that it considers fair and equitable to both sides, not just to one. And if you're dividing one household into two, the resolution has to be fair to both sides. Sometimes I'll put the question to them, what do you think would be, you had to write your own order here, your own agreement. And the one stipulation was it had to be fair to both sides, not just to one. What would you write on that piece of paper? And sometimes when you put it to them in that fashion, they're almost embarrassed to make it too one-sided in favor of them, as they might in court if a lawyer's arguing for them in a court. When they're asked to say, be fair to both sides, now you start to get the possibility, the breakthroughs of some mutual fairness, and they start to come up with budgets that work. It ties into, as you asked before, Carl, about, well, when you take the total savings, the total spending, well, that's a good starting point. Is you can reach an agreement on what the total savings and spending was. Okay, that's what it was. Now, what's a fair way to divide that in some fashion? Now, that doesn't mean it's 50-50, obviously, because alimony very rarely will end up in a 50-50 situation for a lot of reasons, except maybe, in very, very, senior citizen type cases and stuff like that. But I explained that to them too. And then you try to get them to come up with their own understanding as what is fair. And if they reach an agreement on it, you don't have to get into every single item in the budget. to reach that resolution. You just kind of get to it through the express lane.
Okay, Gabrielle, anything to add to that?
Well, as I said before, sometimes going through this process has made them see the error of their ways. So they might have like almost nothing in savings, and now they're 50 getting this divorce. And now they're starting to realize, oh, we need to do something about this. And it's going to be even harder now that we have two households, but we need to address it. How can we do something about this? What's feasible? So we have a discussion about that. Other than that, I pretty much agree with.
Okay, let's turn to statutory factors. Okay.
Okay.
There are, I think, 14 statutory factors. Yep. The last one being anything the court deems relevant, something like that.
That was my favorite factor. I used it all the time.
Yeah, that's and that's why I always told my clients, you know what, this is always a crapshoot. If you had 13 factors, that'd be one thing. The 14th one really puts it into the crapshoot category. So, do you give the statutory factors out to your clients? Question one. And question two, do you go over them one by one by one with the clients, like you might do if you were a lawyer with a consultation or advising your clients? Gabrielle?
Well, I don't go over one by one. I talk about what the statute says in general and try to give them guidance for their situation. And when I say guidance, I don't give them legal advice, but I talk about the framework of the law in a very neutral fashion. And, this is, there's no single person out there that can predict what a judge is going to do in their case if they go to court. So it has to work for them, and, ultimately each person there's only so much in the pot of money, right? And it has to be done so that each person can live and take care of the children if the children are still young, and meaning under 18. If one person has priorities, they're going to spend more on clothes and less on electricity, they can choose to do that, of course. There's always that flexibility, but let's see if we can come up with something realistic within what money there's going to be. Sometimes you get really lucky and you have a person that hasn't worked during the marriage and now is going to work. So the really good news about that is now you have increased income to help compensate for the increased cost of two households. Of course, when you start talking more than 5 children, then that doesn't do much good. But
back to the statutory factors. Okay. Yeah. So on the statutory factors, okay, I understand what you do. Now, Larry, what do you do?
I don't sit there and go through and try to make findings or recommendations on each factor. I think I point out that there is a statute. I point out in an educational manner that the statute it's somewhat vague and does not have a specific formula, because a lot of times people come in and they believe there's some formula for alimony, and there's not. And to the contrary, I want them to understand that if they don't settle it and you're putting it up in front of a judge, that you could theoretically get 5 different alimony numbers before 5 different judges on the same exact facts, and it doesn't mean any of them are wrong. It simply means that courts have reasonable discretion, and the factors are so broad in how they're written by the legislature that nobody could really say for certain what the number is going to be. I want them to understand that it's not just about marital lifestyle, because a lot of people think it is, that it's just one of the facts, especially under the 2014 amendments. The legislature was very clear to indicate no one factor is superior to the other. That includes marital lifestyle. And that they see that it's a very long, extensive process if they were to go to court on this. And this is why lawyers and judges sometimes get all, fighting about an alimony issue. It could take a very long time. So I alert them to the statute. I indicate what the statute is. I encourage them to read the statute so they have an understanding about it, and then try to have a discussion about how we can resolve it in a manner that's fair to both sides. Again, pointing out, as you referenced, Carl, that there is that catch-all factor at the end, that even after you go through all the factors, a court within its reasonable discretion could still do anything it determines to be fair and equitable under the circumstances. But they're
Okay.
aware there's a statute. I want to make them aware there's a statute. I
Mhm.
hope they read it, you know.
Okay, now let's move on to rules of thumb. Okay, this is going to be contentious, I think, not necessarily between you, but other people. In your experience, does a rule or rules of thumb exist? Not in the court system. Let's be very clear right up front. We're not talking about whether judges can use rules of thumb. I know they cannot. They can't do anything which is a mechanical approach. They must go through the statutory factors. I'm now talking about outside of court, in mediation, or when attorneys are advising clients. Do rules of thumb exist? Larry.
Informally and historically, it was an unwritten, whether you call it an unwritten rule or unwritten custom, that many lawyers used, that there was in fact a rule of thumb for alimony. That being, it was essentially 1/3 of the difference in the parties' gross income. However, there are a couple of items that have to be considered. First of all, as you just pointed out, Carl, that rule of thumb was never a rule, and nor was it anything that any judge ever followed or was required to follow, because alimony was specifically not based on any kind of formula or calculation. So you start making a rule based on a calculation, it completely goes against the law. So what happened is when alimony was still taxable up until 2018 under the federal tax code, that's where that rule of thumb kind of developed over time. And without getting into a whole history lesson here, there was a reason why that rule came about, essentially because in one case from 70 years ago, that's what a court found was an appropriate application of alimony. And so that kind of took on a life of its own, as if that applied in every case. The problem with it, with any of these rules of thumb, is you're equating every case as if they're identical, without considering the fact that, you know, if it's 1/3 of the difference, well, what about how long the marriage was? Or what about the age of the parties? Or what about the health of the parties? Or what about unequal equitable distribution? Or what about childcare responsibilities? It oversimplified things. So a lot of attorneys used it as a starting point in an analysis, saying, okay, this is the quote unofficial rule of thumb, but there are factors in this case which may sway it one way or the other. Attorneys sometimes used it in order to see if they were in the right ballpark in terms of what a mediator might recommend or what an ESP panelist might recommend. And as long as both parties were comfortable with the number and understood that there was no binding rule of thumb, you could make up any quote rule of thumb that you want as a guide. It doesn't mean it's going to, as long as it's not binding on anyone, you could use anything to help resolve a case. What happened is in 2018, the federal government, the Congress, and the president passed a new tax code, which made alimony non-taxable and non-deductible. So that prior rule of thumb, which talked about 1/3 of the difference in gross income, now became essentially useless. It became outdated. And so a lot of people in the legal fields were scrambling, saying, well, what's the new rule of thumb now that we have it non-taxable? And so there are all kinds of theories about what the new rule of thumb is, but one thing is for certain: whatever anyone says the quote new rule of thumb is, it's a rule of thumb that has about maybe a year and a half of history to it. And it's new, and it doesn't have the same roots that the quote 1/3 rule did. And so it's almost like new case law. It's something, but worse than new case law, because it's just not binding in any fashion. And there really is no major consistency that I see so far in terms of new rules of thumb. People are quoting all kinds of things.
So Larry, do you tell your clients there is or are rules of thumb?
I bring up to them, because I'm aware that when people come in, they probably have spoken to 100 other people, some who they may not even know, online or through chat rooms, or a friend of a friend of a friend of a lawyer, and they have these predispositions and preconceptions sometimes that there are rule of thumbs. So I bring it up to point out to them that there are no official rule of thumbs and there are no calculations. I bring up to them that many attorneys in the past use this 1/3 concept in the context of settlement negotiations, and for a lot of people, they found that to be acceptable. I point out to them that at the present time, people use kind of different sorts of quote unofficial rule of thumbs, and people find them to be acceptable. So that if they hear about them in their travels or in their internet searches or whatever, they at least know what it is. But I want to make them understand that they're not bound by any of those rules of thumbs, nor would any court impose it upon them if they were to go to a trial.
Okay, Gabrielle, same question.
Again, hard to follow Judge Jones. So yes, but I will, okay, the new rule of thumb that I find most people using is between 22 and 25% of the difference in gross incomes because of the impact of the tax change. And I will often use that as just, this is a ballpark number, but we're going to go and do this the right way with budgets and so forth. And so it's just another tool to throw in there. It's never a be all and end all in itself. That would be completely inappropriate in my view. But it's helpful because it's something people can grab on and see, oh, this is a ballpark number. And obviously, you know, the length of marriage and other factors are also going to play into where you are. So for example, in the old rule of thumb, somebody had a 5-year or 7-year marriage, what I would consider short term, you know, we were looking at maybe 20%, not 30%. So I find it very interesting that in Middlesex, we looked at 33% for, say, a 20-year marriage, and in Mercer, 30%. So there's also some variation in the way the rule of thumb is used from county to county, and of course, judge to judge, et cetera. So as long as people really understand, there's a lot of logical things that you look at, the factors that are cited, and there's no guarantee. Nobody could guarantee what the end result will be because it has to work for them, and it has to work for them in context of the hard work we did on the budgets, that we made them realistic.
So do you tell your clients there is at least one rule of thumb?
Yes,
Okay,
I reference
tell
it.
them that. Okay.
Yes.
So let me recount my experience when I was practicing, which is when I came to Alimony or coming up to Alimony, I always asked them to go to a review attorney, an attorney. Even if they didn't have an attorney, go to an attorney and get some advice from an attorney. You don't have to retain them to do the whole thing, just on the alimony issue. And I always said to them, what you need to ask your attorney is, with respect to alimony, just talk about amount for a minute. What's the best, worst, and most likely amount of alimony that you would pay? I would say almost every time they came back with the ones who weren't gaming this, you know, trying to negotiate in the mediation, they came back at about a third. That's what their review attorney said. And I might ask them now and then, oh, did they go over statutory factors with you? No. Did they ask to see your budget? No. Did they ask? No. Almost every time they came back with a number or a range, but it was pretty much a rule of thumb.
Well, but Carl, you know, they kind of like lend into each other, because if you're able as a mediator to reach a number, which is consistent, which happens to be somewhat consistent with the rule of thumb for independent reasons, and they're going to go to a review attorney, and let's assume that review attorney is going to simply apply this rule of thumb, then the numbers will be consistent.
Right.
And nobody's going to protest. If the number which you're coming up with is, or the numbers that the parties are agreeing with, is radically different than this quote unofficial rule of thumb, and they're going to go to a review attorney, at the very least, there has to be some kind of discussion as to why it is different, so that when they go to the review attorney, they're not getting all these mixed signals.
Yes. Okay. Now, some people I know as sort of, and I'm going to call it a rule of thumb, but I'll describe it and see if that's appropriate or not. What they use is, rather than 22 or 22.5% or whatever it is, they'll use the child support guidelines, and they'll put in obviously the incomes of each party, and then an alimony number, paid, received. And if the distribution of net income between the parties, the recipient party, is in the 40% range, above 40%, somewhere in there, they feel comfortable then then that's in the ballpark for the right amount of alimony. Now, I call that a rule of thumb because it's mechanical, right? There's no analysis, it's just mechanical. So, Larry, do you use that?
Well, I think even though some may say it's 6 versus half a dozen, there's kind of the same thing. I think that approach is more consistent with what a court would do in a fact-finding analysis. Because remember, if you were to have a trial on alimony, a court has to determine, okay, if I award this amount of alimony or that amount of alimony, what are both sides going to be left with based upon their needs, their budgets, their ability to pay, etc. So it's very hard to do that, to just pick a number without seeing what the effect of that number is going to be. So even before the guideline, even before alimony became non-taxable, what you could do, what judges could do, and I did it from time to time, not on every case, but from time to time, I wanted to see if I had a particular number in mind. I wanted to run it in and see what the effect of that number was going to be. What was each party going to be left with after Uncle Sam took their piece, after tax went into effect, and all the other stuff? It was important to know, because otherwise it's just, you're just putting a number out there and not really tying it into what they're going to be able to spend based upon the budgets and everything else that's in this, that are factors in the statute. So even more so, now that alimony is non-taxable, there's an ability to do that, whether you use the guidelines or whether you use, I know a lot of accountants out there have these, these formulas, software where you just put it in and it'll tell you, what it's going to be. And, it gives you at least some reasonable ballpark idea as to what each one's going to be left with. So if the one paying the alimony is left with 60% of the combined income between the parties after taxes, not 60% of his income or her income, 60% of the combined, you got to remember that. And then the other one's left with 40%. Some people might feel that is generally fair and more fair than a 50-50, where the one who's doing, who's working is giving half of it to the one who's not working. And more fair than if someone is only left with, 25%, even if they had a long-term marriage and let's say the supported spouse really helped the supporting spouse get to where he or she is in life. So that 40% number, I've heard it. I've heard it come out a lot. In a lot of cases, it can be a very fair resolution. I'm not saying in every case, but if you want to talk about unofficial rules of thumb, to come up with a number that's in that ballpark, I think in a lot of cases, it sets a barometer for consideration of what might be a fair resolution. But again, you can't just stick with a number. You got to take a look at all the factors and the facts and see if it makes sense.
Okay, Gabrielle, do you use that one?
Well, what I do is I actually do an Excel spreadsheet. I could pull one up and share my screen if you wish. But I look at total net income, what their budget, what each person's budget is, and what number would the payer have to pay for each of them to share equally the pain and come at the same percentage of their respective budgets. So I actually do an Excel spreadsheet to determine that. And then I kind of look and say, okay, are we in the 40-60 ballpark? Because many cases, in fact, end up approximately in that ballpark, and it seems to be reasonably fair.
Okay.
So I don't start with that. I just see, it's just like a little double check for me, but I actually work with the budgets themselves. That's why we spend so much time on the budgets. We really want to get them so both parties agree on them and understand them.
So how much time would you typically spend on the budgets, Gabrielle?
At least one full session. My typical session's an hour and a half long, commonly two.
Okay. And
because
you're
a lot
going
of times
over...
people can't, you give them the homework of doing the budget and they come back with a pretty bad mishmash. And I have to really work my way through it with them. Like, I know a 2,000 square foot house, when you've done enough of these in your life, you have a sense as to what is a normal utility bill, right? If it's 2,000 or 2,500 or 4,000, I have some sense of what a typical utility bill is on average and those things, because I've done so many. Likewise with food, I know that, somebody puts $2,000 a month for food, that's on the high side, but maybe they have 12 kids and maybe that makes sense. But generally it wouldn't make sense. So I can kind of help people where they just totally get stuck.
So what you're doing then when you're saying, well, this seems high or whatever, whether it's utilities or food, what you're doing is asking a question so that they can provide more support?
Yes,
Saying to them,
absolutely.
let's say that they are spending $2,000 on food. Would you ever say, well, you can't afford to do that anymore?
I let the numbers do that work. You know,
Okay.
we
You're not,
show what the total net income is, and if they come up with a budget that major overflows that, how is that going to work? How is that going to be realistic?
okay, but you're leaving it up to the,
Wherever they choose to cut it. But bottom line is, there's usually a fixed number of dollars that you have to work with.
okay, but you're leaving it up to the parties to figure out how they cut in order to meet whatever dollars they have to live on.
I help them with it. I help them with it. Like if they can just do it, great. And that's not my typical couple. Most couples, even well-educated couples, really don't have a good sense of their budget and don't really, their initial stab isn't very realistic.
But
So
again, you're not making a value judgment as to people
Right.
who are you're spending too much money on your hairstylist. You're spending
Oh,
too
I'm not
much
gonna-
money on food. As long
That's
as
not
it's
my business.
accurate, then that is okay. So
yes.
the spreadsheet that you use, is it the same format as the CIS?
The spreadsheet, I use the CIS itself
Okay.
for the budget.
Okay, for the budget and the
But when I'm
balance
doing
sheet.
an analysis of the budget and what alimony works for both of them, that's a spreadsheet I just made up.
You made that up. Could you share that?
I could try. Let me try.
No, not right now.
Oh.
I'm sorry. Could you share that with the people who are watching? If you
Yes,
send it
though
to me,
I
I
have to
distribute it.
caveat that and say, you know, I know exactly what it is when I'm doing it, and hopefully the clients do too. But just looking at it out of context, not in a particular case, people might find it confusing. But you know, again, I'm happy to answer questions.
Okay. So let's say the parties are not represented when they first come to you, and you've gotten to alimony, or you're getting to alimony. Do you require your clients to see an attorney before you go to alimony? Gabrielle,
No.
I see your head is no. That's a no, right?
The exception was that case I told you about, where she made 1.3 million and he made 250,000. And there's a significant discrepancy of income, obviously. But there's also extraordinary savings of 20 million. And I felt it was my obligation to bring up the issue of alimony. And she, oh my God, I got the laser eyes, I call them. Like, you're now dead. The fact that I even brought it up. And she turns to him and she says, if you make me pay you alimony, I am not going to be your friend. And he's like, oh, I don't want alimony like this, right?
So
I didn't feel that was the right way to come to that determination. That might be the right answer. So in that case, that extraordinary case, I asked him to consult with a lawyer. I give him a whole bunch of names, and they could go to whoever they want, of course. And I asked that lawyer call me. So I knew that, in fact, that discussion happened.
So if that person had said to you, the husband, no, I'm not going to do that, would you have terminated mediation? I mean, after all, these are not people who are going to live in poverty in any case, right? So
No,
would you have
I mean, I'm not sure
mediation?
alimony would have been awarded, even though there's a significant discrepancy in income. The guy was walking away with $10 million.
Okay, so the question is, if the person had said
Right,
no,
I don't know. I mean, that would depend on my feeling. Like, as I said, he literally did this. That literally is what happened. I'll never forget. This case was a little unusual. So I didn't feel that indicated a healthy emotional response.
Okay,
So
Larry,
in that case, I would be troubled.
what would you have done in that situation? Would you, first of all, do you require your clients to see an attorney before you deal with alimony?
I don't require them to see an attorney really on any issue. I recommend in writing that both sides see an attorney before signing off on any of these issues, including but not limited to alimony. It wasn't just limited to alimony. And so obviously, if you have a case, for example, if I felt that somebody was waiving what was clearly a significant right to alimony, and I felt that they didn't really understand what they were doing, I would not sign off on something like that, not just on alimony, but on any issue where I felt that the other side just didn't know what they were going to say. You got to, both sides need to speak with an attorney. And I say, I'll be happy to speak with the attorney these days on Zoom or by phone, whatever it is. Because you don't want to be in a position, and I don't think a mediator should ever put themselves in a position where they against their own better judgment, they're signing off on something that they feel is really unfair or unequitable, because now that's not what you're there for. You're there to try to help the parties reach a fair resolution. Now, if they don't want to see an attorney, if they refuse to see an attorney, depending on how significant you see this issue is, you could still make a judgment on a case-by-case basis whether you'll still sign off on an MOU or whether you won't. In a case, if there was an $800,000 difference in income and then an alimony claim, and one side was giving it up because the other side says, I'm not going to be your friend, in that type of hypothetical situation, I wouldn't have a comfort level, honestly, in signing off on something like that without directing them to see an attorney first. I think that's what Gabrielle is saying she did. Because the fact that someone says no at that moment with the person in front of them doesn't mean it was really thought out, doesn't mean they had the ability to have some thought about it in the privacy of a consult with an attorney. And at the very least, they should consult with an attorney first before making a decision of that great significance. If they don't want to, they don't have to, but that doesn't mean you have to sign off on it either. Or you could put in a clause in the agreement which says very clearly, the mediator has strongly recommended both sides seek counsel, but both sides have indicated they are not willing to do so. Now, even if you did put something like that in there, there could be a problem down the line, because one side could say the other side coerced them into it, or there was an imbalance of power, or you didn't know there was prior domestic violence, or something along those lines. So even in those situations, you have to tread really carefully if someone is about to give up something that is, from an objective standpoint, is a significant claim for nothing.
Okay, so we are just about at the end. There's one last question, and it is, how insistent are you in urging the clients to consult with an attorney at the outset of a mediation, as opposed to doing so at the conclusion? Gabrielle?
So it's actually right in my mediation agreement that I encourage people to consult with an attorney of their own choosing for them individually. And when people ask me about it, obviously I'm an attorney. I'm in favor of attorneys. I think attorneys are terrific. So do they have to do it? No. Do I think it's advisable and recommend it? Yes. Okay. And I'm fine with people checking between each mediation session, just touching base with the attorney. And I point this out at the beginning, because the great advantage of doing that is if the attorney thinks something has gone really off rail, they can fix it before we get to a final conclusion. And even if the attorney is fine all the way through, then when they get the final agreement, they know how we got there because they were part of the process. So I actually think that's healthy myself.
Okay.
But of course,
how insistent are you?
I agree with Gabrielle. I think especially now that everyone's using Zoom after COVID, it makes it even more cost efficient to deal with it in that fashion. I explain to the litigants, I say, look, most of the time when they don't want attorneys there, they're trying to save money. And I understand. I say, look, that's fine. But if you have attorneys, through Zoom, we could have our conference, meaning just the parties. And then before anyone signs, if there are questions or concerns, I could speak with both of the attorneys so that everyone is on the same page. And if there is a problem, like Gabrielle has indicated, we can address it before mediation concludes rather than trying to undo something after the fact. And most of the time, I think people are open to that concept. I'm doing one literally today in the same fashion, where we're meeting just with the parties on Zoom, but then I'm going to meet with the attorney separately on Zoom for 15 minutes or whatever, make sure everyone's on the same page. I think it's a wise way to go, quite frankly.
Okay, and with that, we are done. I want to thank you
for
very
everyone
much.
Who participated.
It was a lot of fun. I think you really did a great job, and I hope everyone enjoyed it. And upcoming events, I think it is on July 20th. We have our next Tech Time with Lawrence and Carl. And on the 27th, I hope those are Mondays, Jeff Urbach is going to be giving a presentation on business valuation in the age of COVID. So please look for the notices that will be coming out shortly on the next Tech Time. So thank you very much, and have a great day, everyone.
Thank you for having us,
Thank you,
Carl.
Carl, for
Yeah.
making this happen.
Thanks to all the attendees for
Yeah.
participating. Take care.
Have a great week.